Good morning, everyone. Thank you for joining us. We'll just give it a couple of minutes for everyone to log in. Good morning, everyone. We've got a good group of participants. We're going to give it another minute or two to let folks log in. I love to see that folks are introducing themselves in the chat. Feel free to do that if you are comfortable and so inclined, and we'll get started in a minute or two. Okay, let's go ahead and get started. Good morning, folks. Welcome to this webinar. We are going to be talking today about special immigrant juvenile status, a very important form of relief for immigrant children who've been abused or abandoned or neglected. My name is Hillary Richardson. I use she, her pronouns, and I am the managing attorney of the non-detained kids team here at NIJC. And I'm thrilled to be introducing my colleague, Jordan Mason, who will be giving the training today. I just want to acknowledge the moment that we're in here in Chicago, especially, but across the country, of just unprecedented enforcement against our communities. We're starting to see the ICE enforcement ramp up here in Chicago, as well as in other places. So I know that this is a really tough time for many of us, our families, our friends, and our clients. And so I'm grateful to you all for taking the time to be here today, and for your ongoing advocacy. I'm really inspired by the work that all of you do, and just wanted to extend that thanks to everyone who is in the fight to protect our neighbors. Um, Moving forward today, as I mentioned, my colleague Jordan Mason, who is a staff attorney on the Non-Detained Kids Project and an expert in SIJS cases, will be talking us through today's agenda. I just want to give an overview of what's going to happen today. The webinar today will be recorded and the slides will be circulated. So if you miss anything, or if you have questions, or if you just want to make sure you have this for reference, it will be available. Don't worry about that. This will be webinar format, so there won't be live unmuted questions, but you can feel free to put questions in the chat or the Q&A. Berenice and I will be monitoring those, and we'll make sure that we get to those. There will also be a Q&A at the end. Today, we're going to be providing a general overview of Special Immigrant Juvenile Status, or SIJS. That will include steps to obtain the SIJS predicate order, and this is only for how this process works in Illinois. The predicate order process is state-based, so if you're joining us from somewhere other than Illinois, just keep in mind that that process may look a little bit different in your state. After Jordan gives the brief overview of a couple of types of predicate orders that you can obtain in Illinois, she'll review the process for filing the SIJS petition with the immigration authorities, and then the process for adjustment of status, which she'll go into more detail about. We do want to point out NIJC gives a number of SIJS clinics with a lot more detail, as well as step-by-step resources for filing for these SIJS predicate orders in Illinois. That portion of the program is a little bit shortened today to make sure we can also go over the immigration piece. But if you are looking to take an SIJS predicate order case and you want more detail, those will be available on our website, and you can also keep an eye out for more in-depth trainings on the specific type of predicate order that you are looking into. It is not required to take a pro bono case from NIJC for attending today's webinar, but we always welcome those inquiries. We definitely always have kids who are in need of those orders. So if you are interested at the end, feel free to reach out to the three of us, and we will talk to you more in detail about what that entails. So for today's agenda, as I mentioned, we're going to go over the basic overview, the predicate order, the immigration piece, and then the Q&A. And before I turn it over to Jordan, I just want to mention quickly NIJC's mission and our model. So the mission should be up on the screen momentarily. NIJC is a legal services organization that provides direct legal services as well as advocacy and impact litigation on behalf of low-income immigrants across the country. We have offices in Chicago, in Goshen, and Indianapolis, Indiana, as well as offices in San Diego and Washington, D.C. But again, today's panel is focused on these predicate orders specifically as they pertain to Illinois. There are a couple of slides about how our pro bono program works, and Jordan will go into more detail about this at the end for folks who are interested in taking a pro bono case. But just be aware that we do have a strong pro bono program, both for SIJS cases and for all types of immigration relief. So we highly encourage folks to get involved if they are so inclined. And with that, I'm going to turn it over to Jordan Mason, who will be giving today's webinar.
Good morning, everyone. My name is Jordan Mason. I use she, her pronouns, and as Hillary mentioned, I am a staff attorney on the Non-Detained Kids Project here at the National Immigrant Justice Center. We are going to start off our webinar with a basic overview of SIJS, which stands for Special Immigrant Juvenile Status. Okay, so what is Special Immigrant Juvenile Status? It is a form of immigration relief available to immigrant children who have suffered abuse, neglect, or abandonment by one or both their parents. And this immigrant child must be living in the United States, under 21 years old, and unmarried. The main benefits of an approved SIJS petition is that it is a pathway to legal permanent residency, also known as a green card, and then eventually citizenship. But please note that an SIJS recipient can never file an immigration petition for either parent. even if there is a non-abusive, neglectful absentee parent, that was not the basis for the SIJS claim. For example, most of the claims that we see at NIJC are one parent based SIJS, where the other non-abusive, neglectful parent obtains either a guardianship order or a custody order, and the child, if they do receive SIJS, cannot petition for them. And this does include once they have become a legal permanent resident and once they have become a naturalized United States citizen. So this is a very big deal, and it's very important to flag this on the outset of the conversation with the SIJS eligible youth, because if they have another alternate type of relief, etc., it is important for them to be aware of all their options and the consequences of proceeding with an SIJS claim. So our main guiding sources of law for an SIJS case is going to be the federal laws, which are sections of the Immigration and Nationality Act, which include the definition and the requirements to be eligible for SIJS, and then includes the adjustment of status section to that of a legal permanent resident. And then we also have the TVPRA, which has a variety of protections and relief and stipulations regarding children in this country, specifically unaccompanied immigrant children who have come to this country without their parents. They arrived alone. Regulations would be Section 8 of the federal regulations, and then for United States Citizenship and Immigration Services guidance, which is shortened to USCIS, we have the policy manual for SIJS, and then we also have the policy manual for adjustment of status applications based on approved SIJS petitions. Okay, we're briefly going to go over the requirements to be eligible for SIJS under the Immigration and Nationality Act, the INA. So INA Section 101A27J has the requirements, and there are 5 requirements. So the first one is going to be that the youth is under 21 years of age, they are unmarried, they are present in the United States, and then the Secretary of Homeland Security consents to the grant of SIJS status, and then the state court piece is as follows. A juvenile court has declared that the child dependent on the court or place them under the custody of a state agency, department, individual, or entity. And this part of the statutory language is very important because most of our cases end up with the child being placed in the custody of an individual, whether that be a parent or non-parent. And it has determined that the child's reunification with one or both their parents is not viable due to abuse, neglect, abandonment, or a similar basis under state law, or a combination of any of the 3. And it has also been determined that it's not in the child's best interest to return to her home country. Real quickly, a juvenile court is any court with jurisdiction under state law to make judicial determinations about the custody and care of juveniles, and you can find that in the federal regulations. And here in Illinois, an example of these juvenile courts would be the Domestic Relations and Parentage Court, a guardianship, which is in the probate court, adoptions, juvenile delinquency, and then child welfare. Okay, moving on to what constitutes abuse, abandonment, and neglect. So the definition of abuse, abandonment, and neglect that is found under your respective state law will govern. So here in Illinois, the definitions found in Illinois state law are going to cover all cases in which you're trying to find SIJS special findings. And please note that federal immigration law does not define abuse, abandonment, or neglect for purposes of an SIJS petition. If there is a federal immigration law definition of abuse, abandonment, or neglect, it does not apply to an SIJS case. And the state court definition will apply even if the harm occurred in another country. In Illinois, these terms are defined in an SIJS specific section of state law, so it is not necessary to look for any other definitions that may be found in Illinois state law. And lastly, the abuse, abandonment, or neglect must have been inflicted by a parent, and maltreatment by other caregivers does not qualify for SIJS. For example, unfortunately, lots of children who come here have experienced maltreatment at the hands of a grandparent or an aunt or uncle in their home country. However, that would not qualify them to be eligible for SIJS. All right, now that we've had our brief overview of what exactly special immigrant juvenile status entails, we are going to discuss how you obtain an SIJS predicate order in Illinois state courts. Okay, so an SIJS case is going to be a three-step process. The very first step, which we are going to discuss here shortly, is obtaining an SIJS predicate order in the respective state court in which you are bringing the case. The second step is going to be the SIJS petition, which is USCIS Form I-360, and that is the federal immigration portion of the case, which will look the same across the country. And then lastly, the adjustment of status application is USCIS Form I-45. Also, federal immigration law governs, so it'll look the same across the country, and that is known as obtaining the green card. But please do note that, as if you can tell here, this is not the full end of the case. The SIJS youth will eventually have to naturalize, but that is so far in the future that we won't be discussing it today. Okay, so just a quick overview of the steps to obtain an SIJS predicate order. The first step is going to look like any other case. You will review the case file and meet with the client. And then the second step is going to be to draft and file your respective petition. And then the third step is going to be service of process for any custody case or providing notice for if you're bringing a guardianship case. And then you will schedule the final hearing, and you will work with your client and prepare their testimony, and then hopefully all will go well at the final hearing, and you will leave with an order with SIJS special findings entered at the final hearing. All right, so what type of case to file in Illinois? So the most common types of cases filed to obtain an SIJS predicate order are custody cases, which are now known as allocation of parental responsibility, and guardianship cases. But please note, SIJS findings can be entered in an adoption case, a juvenile dependency case, or a delinquency case. Another type of cases we often see here on the non-detained kids team is children who are in the custody of Department of Children and Family Services, and the Department of Children and Family Services can also bring a case for in order to get SIJS findings for the child who is in state custody. And then an SIJS predicate order can be obtained when a court places the child in custody of a person or agency like DCFS, or declares a child dependent on the court. But I do want to note that the court does not need to make a separate finding of dependent on the court if it is already entering a custody or guardianship order. All right, I just want to remind everyone that slides will be available after today's presentation, because I understand there's a lot going on here on this slide, but I'll just get right into it. So now we're going to talk about the mandatory language for all petitions and orders and judgments. So what we like to refer to as the SIJS magic language is the language that should mirror the special findings that must be included in the final order as well as the petition, so that the predicate order that you obtain satisfies the SIJS requirements that we briefly spoke about under the INA. And just as a brief reminder, there's going to be 3 mandatory requirements in every petition and in every SIJS predicate order. So the first one, as we talked about, child's reunification with one or both their parents is not viable. Secondly, it's not viable due to abuse, neglect, abandonment, or a similar basis under state law, or a combination of any of the 3. And then thirdly, it would not be in the child's best interest to return to her home country or last country of habitual residence. It is very important that you cite the applicable state law and list the specific facts supporting the finding of harm in your petition and in your proposed predicate order. For example, under Illinois state law, if a child unfortunately has abused one of their parents, physically abusing the other parent, this qualifies as abuse, and it would be very important to include those facts in the petition if you're alleging abuse. And then real quickly, when you're citing to the applicable state law for abuse, abandonment, neglect, The specific citations are going to be as follows. So the Illinois Marriage and Dissolution Marriage Act is going to be governs divorce and custody cases, which are now known as allocation of parental responsibility. The Illinois Parentage Act is going to govern parentage cases. The Illinois Probate Act is going to govern all minor guardianship cases. And then the Juvenile Court Act and the Adoption Act are going to govern child welfare cases, delinquency cases, as well as adoption cases. Okay, so just some general notes on filing a petition and associated fees with filing a petition for an SIJS predicate order. So e-filing is mandatory in all Illinois civil courts. You can visit the link here for more information about e-filing. Quick note, NIJC does use the Odyssey e-file system to file everything associated with an SIJS predicate order case, and it is available free of charge. And from personal experience, it's quite simple and efficient to use. If a SIJS predicate order case from NIJC is taken on by a pro bono attorney, then it does qualify for a fee waiver because we are considered a civil legal service provider. So you will need to create a waiver account in order to e-file a case using the CLSP fee waiver. Please note that if you are a private attorney just deciding to take predicate order cases on your own internally with your firm, you would not be eligible for a CLSP waiver, and you would need to proceed with a typical 298 fee waiver process if your client does need to proceed with a fee waiver. Okay, now we're going to go a little deeper into guardianship cases, which is one of the two most common SIJS predicate order cases that we see here in Illinois. All right, so we're going to do the who, what, when, where, and how of guardianship cases. Firstly, who. So a petitioner must be a resident of the United States who is at least 18 years old or 21 years old if they are petitioning for a post-18 guardianship that is of sound mind and has not been adjudicated mentally disabled by a court, excuse me. Federal felony convictions are going to be considered on a case-by-case basis. So if the petitioner has a felony conviction, it will be considered on a case-by-case basis. But it's very important to note that felony convictions involving harm or threat to children, including sexual-based felonies, will be an absolute bar, and the proposed guardian will not be eligible to bring a guardianship case. And then what is a guardianship? So a guardianship gives daily decision-making authority over a minor to the guardian, but it is very important to note it does not terminate parental rights, and a parent can petition to discharge the guardianship at any time for a minor under 18 years old. Okay, continuing on. So when would you bring a guardianship case as opposed to a custody case? So you would bring a guardianship case when the petitioner who is obtaining the SIJ predicate order is a non-parent, or the minor is over 18 years old but younger than 21 years old, and this is referred to as a post-18 guardianship. So for federal immigration purposes, a child is considered someone who is unmarried and under 21 years old. But obviously in most states laws, a minor is going to be under 18 years old. And a few years back, in order to provide eligibility for SIJS eligible youth between the ages of 18 and 21, Hillary, our managing attorney, was part of an effort to change Illinois law, which now allows for a post-18 guardianship to be brought for those children or any other child who may need one who's between the ages of 18 and 21. So if a child is under 18, the person bringing the guardianship is going to be a non-parent, but a post-18 guardianship filed pursuant to this subsection of Illinois state law can be filed by the parents of the over 18-year-old SIJS eligible youth or a non-parent. But please note that if it is filed by a non-parent, that non-parent does need to be over 21 years old. Okay, where are these brought? So in Cook County, here in Chicago and surrounding area, guardianship cases are heard in the probate court. However, it's important to note that in other counties throughout Illinois, custody and guardianship cases may be heard in the same venue or by the same judge. So we highly recommend that you know the structure of the court and the rules of the court in which you are bringing your case. Okay, so how are guardianship cases allowed? Guardianship cases are covered by the Illinois Probate Act, as we mentioned earlier, and they also meet the custody requirement under the SIJS section of the INA. And as a reminder, if a guardianship order has been entered, dependency on the court does not need to be established. All right, now we're going to move on to required filing. So step one of a guardianship case is going to be the initial filing, and this will be the guardianship petition with the probate court cover sheet attached. And then you're also going to file the CLSP certification so that you don't have to pay any fees associated with the case if that is applicable to your case. And then in Cook County, the initial filing of the guardianship petition will trigger a date to be set for the guardianship hearing, and nothing further is required. However, if you do need to reschedule the guardianship hearing or something comes up, you would want to contact the court clerk in order to reschedule the guardianship hearing. So step two is going to be supplementary exhibits. You are going to want to file the minor's birth certificate and a certified English translation if needed as an exhibit. And then if a parent is deceased, the death certificate and a certified translation will also need to be filed as an exhibit. And then lastly, you're going to want to file the signed and notarized oath and bond as an exhibit. And all of these are going to want to be filed ahead of the final guardianship hearing. And so step three will be you file the final order with SIJS special findings as a proposed order ahead of the hearing. Okay, so for guardianship cases, you're going to be providing notice, and then there's also background checks required in Cook County. So firstly, providing notice. Quick note, service of process is not required for guardianship cases, but parents and adult siblings must be notified of the case. And this does, as of late, include half siblings. So you'll have a variety of options. So option one is going to be return receipt mail. So this would be, for example, if the petitioner has no clue where the respondent resides, if they have no clue where the parents or adult siblings of the minor reside and they think, oh, they were last known to be in this country, you will generically try to send mail, and most likely what will happen is the mail will return. And then option two is appearance and consent, which needs to be signed and notarized. And this would be when the parents or adult siblings enter appearance and consent to the guardianship ahead of the final hearing. And then lastly would be publication to notify everyone that needs to be notified. All right, moving on. So background checks in Cook County, all adults in the home must undergo 2 background checks. So the first background check is going to be the child abuse and neglect trafficking system. And that's going to check for a general, like if you've ever had a case with DCFS, problems with child protective services, such as that, that's what it's checking for. And then the second type is just a criminal background check. And private vendors have different fees, but in Cook County, the cost can be waived by requesting a fee waiver with the Cook County probate judge. All that requires is you email the proposed fee waiver order to the appropriate Cook County email, and then after the judge has signed the order for a fee waiver, the fingerprints can be taken at the Daily Center here in downtown Chicago free of cost, which is a really nice benefit to our clients. I do want to note that because of the new administration, the approach to fingerprinting has been adjusted just a little bit. Before, we advised petitioners that it was not the most risky thing to be doing, and it's not like insanely risky now, but there is increased risk with heightened immigration enforcement. As you can imagine, a lot of the petitioners bringing these cases are also dealing with a variety of immigration background, immigration status, immigration cases. So they may be a little bit nervous to be fingerprinted or going to a court, but it is very important to let them know that the fingerprints taken as a part of the criminal background check have nothing to do with the federal immigration system, and the fingerprints they are not being screened for immigration violations, immigration status, anything related to their immigration case. They're simply being screened for crimes that they may have committed in the past. And then we would also suggest that you attend the fingerprinting appointment with your clients if they do have a non-stable immigration status, just so they feel a bit more safe and secure, so that they have an attorney with them during this appointment. All right, and then we're going to move on. Okay, for the guardianship hearing, you're gonna want to do a handful of things. So you're gonna want to email courtesy copies to the judge several days prior to the hearing. I would recommend a week, just so they have them well in advance. You want to include the proposed final order with SIJS findings, and then you want to request an interpreter well ahead of the hearing. I would say the most common interpretation requested would be Spanish. So that is easily accessible in most courts of Cook County and throughout the state of Illinois. But for example, if your client speaks a less common indigenous language from a small part of Guatemala, you would want to request that probably as soon as you file the petition, because that type of interpretation is significantly harder to find for the court system. And then probate hearings are held via Zoom, which is very nice for your clients, because besides the fingerprint appointment in Cook County, you can let them know that they will not be having to go to a in-person hearing in court. And then you want to explain to them well ahead of time what to expect during this guardianship hearing. And if all goes well, there should only be one hearing for the guardianship case. And I just want to note that Cook County probate judges are pretty familiar with SIJS predicate orders, but it's important to come prepared to explain SIJS and point to the appropriate legal authority if needed, especially if you're in more rural Illinois counties. They may not be as familiar, and you want to be as prepared as possible to explain the validity of your claim and why it is allowed to proceed, and why a state court judge is allowed to enter findings to an SIJS case. Okay, we've reached the first CLE word for today, which is going to be predicate. And just a gentle reminder, these won't be available after the presentation, so please write it down somewhere for your record keeping so that you can fill out the CLE survey after the webinar today. One more time, the first CLE word for today is predicate. All right, now we're going to move on to the second most common type of SIJS predicate order case that we see here in Illinois, and that is going to be an allocation of parental responsibility, APR case, formerly known as custody. So now we're going to do the who, what, when, where, and how of APR cases. So who brings this type of case? A petitioner must be a resident of the United States that physically resides with the minor and is the parent of the minor. What is this? So an APR judgment determines the physical residence of a child, as well as legal decision-making authority, responsibility, and parenting time. As mentioned above, an APR petition is typically filed by a parent of a minor that is younger than 18 years old. And an APR petition can be filed independently or as a part of a divorce petition, but married parties can also file an APR petition without seeking a divorce from the respondent. All right, when would you bring this type of case? So you would bring this type of case when the petitioner is a parent of the SIJS eligible minor, and you would bring it before the SIJS eligible minor turns 18 years old. I do want to note that because children are eligible for SIJS up until 21, should you have a case in which the minor does turn 19, the parent can still bring a post-18 guardianship for their 19-year-old child. Okay, so just like guardianship cases in Cook County, APR cases are heard separately in the Domestic Relations Division, but in other counties throughout Illinois, they might be heard in the same venue or by the same judge. And so just a quick reminder again, please look up the structure and procedures in the court system in which you are bringing your case. So APR cases are going to be governed by the Illinois Marriage and Dissolution of Marriage Act. And so that means when you are citing the applicable state law, you will be citing to this particular section of Illinois state law. And it is very important if you're doing different types, for example, a guardianship case and an APR case, that you cite the applicable state law, which would be separate statutory schemes here. Okay, so quick note, parenting classes are required for all domestic relations cases in Cook County, so involving children. So this would be even default cases. So if the respondent parent is completely in default, it doesn't matter. But most judges don't care to an extreme degree if the parenting class is not completed in default cases, but some do want strict compliance. So it is our recommendation that all petitioners in an APR case complete the parenting class just to be sure. The class is called Children in Between online, and you can just simply Google it and it'll come up. And there is a fee for the class, but it can be waived if you file the file stamped CLSP form with the online class system. And the class takes about 4 hours to complete online. And I do want to note that your client does not need, the petitioner does not need to complete the class in 4 hours straight. If they want to do half an hour here, an hour there, half an hour another time, that is completely fine. The most important thing to note that is if they start the class on September 1st, they must complete all 4 hours of the class by October 1st within 30 days of starting the class. So as long as they complete it within 30 days, it doesn't matter how long it takes them to do it. The client also must have a passing rate of 80%, and then the class is available in both English and Spanish. Once your client has finished the class and passed the class with a rate above 80%, they will receive a certification of completion, and you will file that in the online filing system as an exhibit for the case. Okay, just a reminder, you will receive this slide after the presentation because I understand there's a lot going on, but now we're going to talk about required filings and hearings involved in an APR case. So step 1 is the initial filing, which you will file the petition with the domestic relations cover sheet, the affidavit of military service, and their certification of legal service provider form. And then, as we talked about before, this is not available for petitions filed by a private attorney that did not take the case from NIJC, and you will need to go through the traditional 298 fee waiver process. Step 2 is going to be service of process, and then step 3 is going to be the default hearing. And here the judge should find one of 3 things: that the respondent is in default for not filing an appearance before publication had run, personal service has been provided, or consent and waiver of service was signed and filed with the court. And then lastly, step 4 will be you'll draft the final order and file your motion for the final prove-up hearing. Some quick notes is that after the petition is filed, unlike in a guardianship case, it is your responsibility to move the case forward. So for example, if you file the initial petition and then do nothing, nothing will happen. The case will just sit there. So you need to push your case along by proceeding with service of process, the default hearing, etc. And then secondly, this is the typical process for a Cook County case. So please inquire with the clerk's office or check your court's website for the proper case and hearing procedures if you are not in Cook County. Okay, so we're going to do a detailed breakdown of step 2, service of process. And then again, reminder, this is a typical process for Cook County cases, so it's important to understand the process in your respective jurisdiction. So firstly, if you have a deceased respondent, you can file a motion to appoint a special representative, and at what would be your first hearing, the judge is able to appoint a special representative to the state of the respondent, which would essentially act as what it sounds like, the representative for the respondent throughout the duration of your APR case. And then moving on to our options for when the respondent is living. So option 1 is going to be personal service. Option 2 is going to be consent and waiver of service. And then option 3 is going to be motion for service by publication, which is probably our most common type of service of process. So you will file the motion for service by publication, and at the same time, you will also file the affidavit for service by publication and the affidavit of due diligence with this motion. So this will prompt you to have your first hearing set, which will be the publication hearing. And during this hearing, you will ask the judge for leave to serve the respondent via publication. And if all goes well, the judge will grant that request. Then you'll be able to publish, and then you'll be able to file your certificate and motion for default 30 days after the first publication date. So for example, if you published your first date was September 9th, you would be able to file default on October 9th. All right, step 4, the prove-up hearing. So our preparation timeline is going to be as follows. This is what we recommend. So about 7 days in advance, you'll want to send all courtesy copies to the judge and request an interpreter if needed. About 48 hours in advance is a good idea to confirm the request for the interpreter. And then depending on what's best for your client, whether it's a day before or earlier, you're going to want to go over all of the direct exam questions with the client to make sure the hearing goes as smoothly as possible. And then the day of the hearing, you'll want to log on to Zoom, check in, appear on the case, and follow your script. I do want to note that although Cook County functions primarily via Zoom for all types of custody and guardianship cases, that is not the case in the entire state of Illinois. So it is good to double check with your court whether or not they require an in-person hearing for the final prove-up hearing. And then within 1 to 2 weeks after the case, you will obtain the and file the transcript of proceedings. So for the client's testimony, it is probably best to have a short and concise direct examination where the client addresses each allegation in the petition, and this is known as proving up the allegations. You're going to want to review direct examination with the client ahead of time, and please do not ask any questions in court if you do not know how the client will respond. And then young children are not allowed in court, but older teens should be available in case the judge wants to speak with them. So for example, if you're bringing an APR case and the petitioner has 3 children, a 15-year-old and then a 3 and a 5-year-old, the 3 and the 5-year-old children would not be allowed to come to the prove-up hearing, but you would want the 15-year-old child to attend with their parent, so just in case the judge wants to speak with them. And then during the prove-up hearing, it is very important to know your judge and to verify whether there are any special requirements that the judge needs. And then you're going to want to bring your memoranda of SIJS law and be prepared to explain SIJS to the courts. It is a statutory requirement that judges consider motions for SIJS findings and that they must enter these findings if it's supported by the evidence. I do want to note that if you do take a pro bono case with NIJC, we do have a variety of templates for the SIJS memo of law, so you will not be complete on your own when drafting that. All right, and then just a quick reminder of the SIJS magic language in the final order. So this language must be included in the final order, as we've mentioned, to satisfy the requirements under the INA, and they're the exact same requirements as for guardianship cases, which are as follows. Child reunification with one or both parents is not viable due to abuse, neglect, abandonment, or a combination of any of the 3 under state law. And it would not be in the child's best interest to return to her home country or country of last habitual residence. And then please cite the applicable state law and list the specific facts supporting the finding of harm. All right, that concludes our section on the state court portion of an SIJS case. And now we will be, which is obtaining the predicate order, and now we will be transitioning over to the immigration portion of an SIJS case, which is filing the petitions with USCIS. So first, we're going to talk about filing the SIJS petition, which is USCIS Form I-360. So a quick timeline here. So as you know, the preliminary step, or step 1, is obtain the SIJS predicate order. So we've already gone over that, so we assume we have that. So the step we're on now is file the SIJS petition. So currently we are receiving approvals between 5 to 16 months, and then Step 3 would be the approval of the SIJS petition. And then step 4 is going to be file the green card application, which is USCIS form I-485. But currently there is a severe visa backlog, and the estimate wait for these kiddos is about 5 to 10 years. We will go into this in more detail once we hit the adjustment of status stage. And then once the adjustment of status application has been filed, if the form I-485 is approved, then the SIJS youth becomes a lawful permanent resident, which is very exciting for them. Just another quick note, as I mentioned prior, this is not the complete end stop of their immigration case. They will need to file for naturalization so that they can become a US citizen, but they will be eligible for that 5 years after they receive lawful permanent residence. All right, just some details about the USCIS Form I-360, which is a petition for Amerasian widower or special immigrant. As you can tell from the title, this is a form that includes a variety of visas. The form is about 20 or so pages long, but not all sections are going to be applicable to a special immigrant juvenile status petitioner. Only the sections for the status they're applying for will be filled out. So there may be at times multiple pages left blank because that is a visa that they are not applying for. And I do want to note the transition of who the client is when we've reached this matter. So when you're obtaining a predicate order, the client is going to be the petitioner, which is someone obtaining guardianship or custody over the minor. So a parent, a family member, whoever the petitioner is. But now that we've obtained the predicate order and we are on the stage where we're filing the SIJS petition for the SIJS eligible minor, the SIJS eligible minor is now the client. And so all the general ethics rules, attorney-client privilege, confidentiality apply to you and your SIJS eligible minor. And so if they do not want you speaking to their parent, their friend, their neighbor, whomever, the person who obtained the predicate order, then you cannot talk about their SIJS case unless they give you consent for you to talk about their SIJS case with that person. Okay, so a quick note, the filing fee is new. So prior to the bill that was passed in July of this year, there was no filing fee for an SIJS petition, nor was there a filing fee for an SIJS adjustment of status, but now there is a new unwaivable filing fee of $250. Unfortunately, it is not waivable. So we do recommend that you talk about this filing fee as soon as possible. If you are an attorney who is representing an SIJS case from start to finish, so predicate order to the end, we would recommend you tell them during the predicate order stage, they have as long as possible to save up for that filing fee. And then important deadline is that the SIJS petition must be filed and received by USCIS prior to the petitioner's 21st birthday. This is where statutory language is very important because the language does not say on or before the 21st birthday of the minor. It says before the 21st birthday of the minor. So for example, if the minor had a birthday of March 15th, that's when they're turning 21, the petition would need to be received by USCIS by March 14th. And that's the latest date it could be received, or the SIJS petitioner would no longer be eligible. And then moving on to ensuring continued eligibility for SIJS, you must ensure that the client is unmarried and living in their court order placement at the time you submit the Form I-360. So if the client has turned 18, for example, then the custody or guardianship order has terminated and the minor does not need to be living with their court ordered placement. You will be able to see on the USCIS form, it does ask if they're living in their court order placement. And if you answer no, there's a way to say, oh, they're not living with them because they've aged out of their custody or guardianship order, and that is completely valid. I do want to note that if you do have a minor who is under a post-18 guardianship, that will terminate on their 21st birthday, so they do need to live with their minor with their court order placement up until the filing, because the petition will be filed before their 21st birthday. And so the guardianship will still be valid during the filing of their petition, but they may move out if the petition is pending for 5 months and they turn 21 in those 5 months, they can move out after the filing as long as the petition is pending with USCIS. And then lastly, it is very important that the minor cannot be married or get married prior to the approval of the I-360. So if the I-360 is pending for, let's say, 6 months, throughout that duration, your client cannot get married. If you do happen to have a client who would like to get married after they have an approved SIJS petition, but before they have adjusted their status, we highly recommend you have them speak to you about proceeding with that marriage. Okay, moving on to filing the SIJS petition. So we have a brief checklist for you. So you're going to want to include a cover letter that cites to the INA section that defines the term special immigrant juvenile. And you're going to want to include a short statement as to the client's eligibility and the date that the predicate order was entered with quotations of the SIJS magic language. So for example, this would include that, client is an unmarried minor who's under 21 years of age and they are physically present in the United States. And then you would literally pull the language from your predicate order that says like reunification with parent is not viable due to abandonment, they should not return to home country, etc. And then you're going to want to include USCIS Form G28 and USCIS Form I-360. The USCIS Form G28 is just the generic notice of appearance for the attorney, so it lets USCIS know that this client is represented for their SIJS petition. And you're going to include a copy of the predicate order, and then you're going to want to include a copy of the client's birth certificate with a certified English translation if necessary. And this is because they do require evidence of the client's age, since age is a requirement to be under 21 years of age when you apply for SIJS. I do want to note that if you do not have access to a client's birth certificate, but they happen to have a valid passport, that would also satisfy this requirement under USCIS guidelines as well as federal labor relations. And then lastly, proof of physical presence in the United States, since the SIJS eligible minor must be in the United States. If the client was an unaccompanied immigrant child, I would use a copy of their Office of Refugee Resettlement Verification of Release form because it shows that they were released to their sponsor in the United States. But if the client was not a UIC, physical presence is normally satisfied by the predicate order explicitly stating that the child lives with the parent or guardian in the United States. I would say NIJC has rarely ever received pushback from USCIS regarding the physical presence requirement, since the predicate order normally establishes this requirement. All right, sort of quickly here, we now have the second CLE word of the day, which is going to be order. And as a reminder, these will not be available again after today's hearing. So the first predicate order, or the first CLE order word was predicate, and the second word is order. So predicate order is going to be your CLE code for today's webinar. All right, I feel like I'm a broken record here, but this slide does also have a lot of language on it as well, and it will be available after today's webinar. So now we're going to talk about the approval stage, which is quite exciting. So SIJS petition approvals are taking about 6 to 8 months. That's what we're seeing, but immigration practitioners across the country have seen timelines all over the place. The USCIS processing times online state that 80% of SIJS petitions are approved within 16 months. So we would recommend that you set client expectations very early on and say that we hope to see an approval around 6 months, but it could potentially take as long as 16 months, just so that no client is caught off guard by an extremely long wait time. If you receive requests for evidence from the government, it can significantly lengthen the period of time in which the SIJS petition remains pending, but we have been seeing approvals still within the range of 6 to 8 months, even with requests for evidence. Okay, so once the Form I-360 has been approved, the client now has special immigrant juvenile status, which is quite exciting. However, the biggest caveat here is, as we mentioned earlier, they will not be able to adjust to lawful permanent residence until their priority date is current. And the priority date is the date that USCIS received the Form I-360. and it is listed on the USCIS receipt notice for the petition and also the approval notice for the petition. And please note that the priority date is not the date the I-360 was approved. So for example, if a client filed their petition on January 1st, 2025, and it was approved on June 1st, 2025, their priority date is going to be January 1st, 2025. So the earlier of those dates. And this priority date will become current when the date for the EB4 category on the visa bulletin is on or after the client's priority date. But please note there's a limited number of people per country who can get a green card through SIJS in a given fiscal year. And so SIJS youth have been subjected to an extreme visa backlog to this limit. Due to this limit, and we have a little screenshot of the visa bulletin right here at the bottom of the slide. You can always find the visa bulletin simply by Googling visa bulletin, and it'll come up on the Department of State, and most of the time you can see the current months, and depending on the time of the month, you can also see the following month. And so this is a screenshot of the employment section of the visa bulletin. SIJS youth have been included in the EB4 category, which is considered an employment-based visa, and it is organized by categories, which they are the highlighted yellow category, and also by country of origin. So the countries listed are going to be China, India, Mexico, and the Philippines. But if you have a client, for example, that's from Honduras or Nigeria, they are going to be included in the all chargeables areas. And so if you go to the very first overlapping section, you're actually going to see that there's currently a U there. So this has been there since I think roughly April, May of 2025, which means that there are no more visas available for SIJS youth in this category. So if a child has a priority date of 2016, it does not matter. There are no visas available, so they cannot apply to adjust their status. If they were eligible to adjust their status before the visa bulletin became unavailable, their case is simply pending with USCIS and there's no movement whatsoever. This is why the visa bulletin can be a tricky part of an SIJS approval, because it is simply unable to be predicted. So it does not move in a linear fashion whatsoever. There are times where if there were visas available, like the line above, like it may say July 8th, 2021 for 4 months in a row. It may move backwards, like 1 month it may be in 2021 and the next month it's in 2018. And then also sometimes, happily, it may jump. About 1.5 years ago, we saw a jump of maybe a year. Went from 1 month to the other, it went forward a year. So within 1 month's time, a year's worth of priority dates became current for SIJS kiddos, which was great. But this does make it an incredibly inconsistent chart and very impossible to predict. So it's very important that you set expectations with your clients early on that they will not be receiving a green card anytime soon. And then going further, that you set expectations that SIJS is not an overnight form of relief. It is a very long process if you consider starting at the predicate order and going all the way to permanent residency and then 5 years of waiting before you can adjust or apply to be a citizen. All right, and then I do want to touch on determination of deferred action, which is one of the things one of the biggest things that have changed with special immigrant juvenile status since the new administration. And in the past, you may be aware that SIJS recipients would also receive a grant of deferred action. I would say the most popular type of deferred action is deferred action against childhood arrivals, and it functions very similarly here. And it awarded them protection from deportation and also eligibility to seek work authorization. However, unfortunately, the new administration did terminate deferred action for SIJS recipients in the summer of 2025. You can look at the policy alert from June to get further details on why they terminated it. Immigration practitioners have not seen an SIJS recipient receive deferred action since roughly March 2025, and USCIS has essentially stopped processing work authorization applicants for SIJS recipients who were granted deferred action prior to this policy change. So what that means is that if a child received an approved SIJS petition and deferred action in August of 2024, but they decided to apply for their work authorization document in May of this year, despite them already having a grant of deferred action, the USCIS is not processing their C-14 EADs, which is quite unfortunate. A bit tangential, but there is pending litigation about whether the government can terminate deferred action like this, and also whether it's appropriate for them to have stopped processing employment authorization documents for the youth with deferred action. And it is still pending, but you can always feel free to look that case up if you are interested. Okay, moving on. The effect of this policy change on SIJS youth who are in removal proceedings. So in the past, SIJS-based deferred action was a strong and often granted basis for the termination of a child's removal proceedings in immigration court. But an approved SIJS petition without deferred action can also be a basis for terminating or administratively closing a child's proceedings with the immigration court, as it is a pathway to adjust their status to that of a legal permanent resident. But I just want to note that it is very important to analyze the risks and benefits of seeking termination of removal proceedings versus administrative closure, and you want to do this on a case-by-case basis. All right, that is going to end our discussion of the SIJS petition. And now we're going to do a brief overview of SIJS-based adjustment of status, which is USCIS Form I-485. All right, so here's the timeline for an adjustment of status application. You're going to file the application. You'll likely receive your receipt notice in about 2 to 4 weeks. And then you're also going to receive a biometric notice for a fingerprinting appointment for any and all applicants who are between the ages of 14 to 79 years old. And then in the past, we really rarely saw interviews for an SIJS-based adjustment of status because they are discretionary. But with this new administration, we are seeing more and more interviews. So it is probably best to discuss that potentiality with your client during the beginning of the adjustment of status case, and then also begin prepping them should you receive an interview notice. And then lastly would be the decision on the adjustment of status application. The timing varies widely, but recently we are seeing approvals taking between 6 to 12 months, which is super exciting. And should the I-485 be approved, your client should receive their legal permanent residence card in the mail, which is very exciting for the clients and the legal representative. Okay, so now we're going to do an overview of eligibility for adjusting status as an approved SIJS youth. So firstly, it requires a lawful or admission or parole into the United States under INA Section 245A. An approved SIJS petition does act as parole under INA Section 245H. Which means that the young person can adjust their status within the United States, even if they originally entered quote unquote unlawfully. So this means that if they cross their border with their parents without having any sort of valid status when they came here originally, they can still adjust status here in the United States because their approved SIJS petition does give them parole. And then adjustment of status also requires that under INA 212A that they be admissible to the United States. And the grounds of admissibility are found under INA 212A. So the thing about an SIJS petition that is quite beneficial, because this is a protection for particularly vulnerable youth who were maltreated in the past, is that there are many grounds that are either not applicable or completely waivable for an adjustment of status application based on an approved SIJS petition. So a certain immigration violations, for example, being present without admission or parole, or not in possession of a valid entry document, or accruing any sort of unlawful presence, as well as public charge, smuggling, and then certain criminal grounds, are all either not applicable or waivable for a SIJS applicant who's adjusting their status. I do want to quickly note that obviously a lot of SIJS applicants are going to be children or young adults by the time they've waited for their priority date to be current. But because of this, it's important to note that juvenile delinquency cases are not criminal cases. So they are not considered the same as like being convicted of a criminal conviction. That doesn't mean to say you don't report that it happened and you don't include it on the application within the client's affidavit, but it is important to understand when you are approaching this type of case that it is not considered a criminal conviction. And then there are grounds of inadmissibility that are applicable to the youth and then are not waivable. So certain criminal grounds that include drug trafficking and terrorism and security related grounds are not waivable and applicable to the client. We will touch on this in even more detail briefly, but I do want to note that if you do have a SIJS youth who is eligible and ready to apply for adjustment of status, that you heavily screen them if they do have criminal convictions in their background or terrorism or security related grounds, because they are not waivable and that makes them ineligible to adjust their status to that of a legal permanent resident. And submitting an application for someone who is not eligible to USCIS could trigger them to be referred to the immigration court to be put in removal proceedings. So it can be quite risky. It's obviously very important to talk about the risks of submitting an application for a client who has a criminal background, and you must talk about that with your client. And it is very important to screen for the effect of submitting this application with the government. Okay, so filing the SIJS-based adjustment of status application with USCIS. So our checklist is as followed. You'll have a detailed cover letter. You'll have your USCIS Form G28, the adjustment of status application. You're also want to include 2 passport-style photos and a government-issued photo ID. And then you're also going to want to include a birth certificate and a certified English translation if necessary, the SIJS approval notice from USCIS, a copy of the current month visa bulletin so that it shows them that their priority date is current, and then a sealed medical exam because there are medical grounds of inadmissibility as well. And this is USCIS Form 693, and your client will have this medical exam done by an approved civil surgeon, which can easily be found via the link on the USCIS website. So you'll be able to find a surgeon near your client. And then you're going to want to include the following documentation if applicable. And so if the client was previously in removal proceedings, you must include a copy of the immigration judge's order that terminated the proceedings. And then if the client has had any police contact, as we've mentioned, there's a very huge preliminary step here. So you're going to carefully assess the risks, as the client couldn't be in danger of removal if they apply when they're ineligible to adjust their status. But if you've determined that they're able to adjust their status and they would like to move forward, you will include copies of any and all criminal dispositions, and you will also include an affidavit from the client explaining rehabilitation and other mitigating factors for discretion. This would be because an adjustment of status application to become a legal permanent is actually a discretionary application. So a part of the approval is that like it's up to the discretion of the adjudicating officer, whether that be a USCIS officer or an immigration judge if you're in immigration court. And for example, a DUI, a singular DUI, does not make someone ineligible to adjust their status to that of a legal permanent resident. However, it can very negatively affect the discretionary aspect of an adjustment of status application. So you would want to include a very detailed affidavit from your client that shows that they've been rehabilitated, and then maybe letters of support from the community, just so you can have some positive factors to mitigate the impact that DUI would have on the discretionary decision making of the adjudicator. All right, and that actually concludes our presentation for today. So now we're going to open it up to questions and answers, and my colleague Berenice will flag the questions for me in the chat, and then I will answer them to the best of my abilities.
Thank you all for all your questions. Oh my God, we have a few. So the first question that I see in the Q&A, but I also saw some in the chat, so I will get to those briefly. The first question is, as SIJS cases, if counsel is licensed in one state, but the child resides in another, how do you go about securing the predicate order in that out-of-state court without running into unauthorized practice issues? And what practical options do you recommend when there's a time crunch, for example, when a child is about to age out and local counsel isn't yet lined up?
Okay, so I'm going to tackle the first part of your question. And if you are licensed in a state in which your client resides in another, I think our pretty simple recommendation would be you would not be able to be the attorney for that case. So you're only going to be able to represent the predicate order section of a case if the client resides in the state in which you are licensed. Because the client does need to reside in the state in which the case is brought, and then the attorney does need to be licensed in that state as well. So the best recommendation we have would be you would need to look for an attorney who is licensed in the state in which the client resides. But that does not mean that once the predicate order is obtained, you wouldn't be able to represent your client for the immigration portion, because that is federal immigration law, as we all know. But for the predicate order portion, you do need to be licensed in the state in which the client resides and in which the case is brought. And then the second part of your question is about aging out. I would say just set realistic expectations with the client, and if they're going to be turning 21, let them know that this is a very urgent matter, and if we cannot have, if a counsel is not lined up, we may not be able to bring this case. And you can also recommend that the client try to find a attorney in their area in which they live that could potentially help them with the predicate order part of their case.
Jordan, if I could jump in here, because some of this question seems to be about sort of building these relationships and networks. So as Jordan pointed out, you have to be licensed to file a predicate order in the state. If you think that SIJS is going to be a big part of your practice, definitely look into requirements for getting licensed in the state that you reside in, right? Because this will be an ongoing problem. But I want to point out at the beginning, many years ago, when we were starting this pro bono program at NIJC, we just started reaching out to folks both in the immigration bar, but especially in the family law bar in the state. It is really important. It's such an important form of immigration relief that I think it is worth trying to build up those relationships in those networks. Check out, events, bar associations, try to build those connections with the local family law bar so that you can have those partnerships available. And even if a family law practitioner is not familiar already with SIJS, most of the predicate order case is going to be just like every other case that they've filed. They may just need to partner with you so that you can review and make sure that the findings are appropriate for SIJS. But really, my recommendation in response to Woodley's question is start building those networks now. And then hopefully you have a good enough relationship in the future that you might even have somebody to run to with an age out case. But it is a process that takes a number of years, and it's taken us a number of years. And fortunately, now many folks in the family law bar in Illinois are familiar with the predicate orders.
All right, thank you. And we do have another question, and this one is from the chat. Can abandonment be that the parent was deported to home country?
Okay, so I'm going to answer this in very classic attorney fashion and say that it depends. Because if, for example, the parent was very unfortunately deported to home country, but is still a very active parent in their child's life, talks to them daily, maintains that parent-child relationship, then no, that would not qualify for abandonment under Illinois state law. But obviously, should the parent be deported to home country and then simply cease trying to maintain a parent-child relationship with their child in the United States, then yes, you could probably make an argument that that qualifies as abandonment under Illinois state law. but as always, it is very fact specific to the client's case.
All right. And then next question. Do you have any redacted samples or filings? We do. We shared the link in the chat, and we have pretty good handouts for whoever wants to take a pro bono case. But even like on our website, we have samples and of almost everything that we do for the predicate order and also for the I-360 and I-45. Okay, next question. Can you share some samples of APR cases where the bio father is not on the child's birth certificate?
Yeah, so that would actually be where you would have to establish paternity. And one of the ways you can do that is voluntary acknowledgement of the paternity by the father of the child. And then also through other means such as an affidavit of people who were there around the time that the child was born. And then also if the mother and father were married at the time that the child was born or within the vicinity of the pregnancy, then there would be an assumption that the child is the father is the husband is the father of the child. And then I might tag Hillary in to provide more specific examples of that we have done in the past to establish paternity.
It's going to be really fact specific, y'all. There are a number of ways that we can do it, but we typically have been able to establish parentage in these cases. So it depends on the judge what kind of requirements they are going to establish for establishing parentage through an APR case. But definitely reach out to us if you have a tricky case, and we can try to provide advice on that. There are also scenarios where if there is no parent, that can be listed on the birth certificate, for example, that in itself can be sufficient for USCIS to establish abandonment. And you would be making that argument before USCIS as opposed to in the predicate order.
Thank you. Next question is, can you bring your own interpreter to probate hearing or need to use a court interpreter?
I actually might tag Hillary in for this because this is a very technical question. I have only ever used the court interpreters, but I've also only ever requested Spanish, which is the most common and easily accessible interpretation. So I'll tag in Hillary to see if she's ever had someone bring their own interpreter.
Yeah, it really is going to depend on the judge. Legally, the courts are required to provide an interpreter in any language requested by the litigant. But depending on, how many interpreters they have that day, and if you have a language that's somewhat unusual, the court may ask for or accept your assistance in bringing in an interpreter. It's a little different on Zoom than it is in person. I think when I did family law many years ago, there were various times in court where the Spanish interpreter was running behind and the judge would let me or another attorney step up and interpret a brief hearing just in the interest of time. But the answer, as always, is going to be it depends. But if you need a court interpreter, the court is required to provide one for you as long as you provide notice.
Thank you. Another question from the chat. So I'm going back and forth, the chat and Q&A. So thank you so much for your questions. What can undocumented parents fearing deportation do in advance to assist the child in SIJS process? Like providing a written statement with necessary information, noting in case of deportation, or unable to take the child due to danger in country and relinquish parental rights?
I'm not quite sure. I understand the call of this question. If you're asking like what an undocumented parent in the United States who's fearing deportation can do in advance, I think my answer to that question would be the most effective thing would be they would be the one obtaining the predicate order should their child be a minor under 18 years of age, or if their child is over 21 years or over 18 but under 21, they could also obtain a post 18 guardianship. And that would be and then obviously they would just want to work with their attorney to address any of their fears regarding deportation. And most commonly that would come up in Cook County with the background check, because that's the most nerve-wracking experience for a parent without status. If I didn't answer your question correctly, please do put it in the chat again and I can try.
Thank you.
It also seems like there's two questions being asked there. One is about safety planning for families who fear detention and deportation. And we have additional resources on that, but I would also direct folks to ICER and to other Illinois-based resources that are specifically focused on safety planning with families. A guardianship isn't always necessary ahead of time if parents fear separation from their children, but what is necessary is having a plan, knowing who your emergency contact is, making sure you have someone who is available to pick up your kids from school, talking to your family and loved ones about what you want to have happen. For example, if you are deported and your children are here, do you want someone to facilitate your children being returned to you in home country? Do you want someone to be designated to care for those children here? So really having those conversations is the most important thing.
Yes. Next question is SIJS predicate order a pathway to legal adoption?
So I'm going to answer that as no. An SIJS predicate order is is what we use to generically referred to as the juvenile state court order that contains the special findings, so that a minor is eligible to apply for SIJS with USCIS. So it's going to have those inability to reunify due to abuse, abandonment, neglect findings. However, as we mentioned, you can include SIJS special findings in an adoption case. So if there's a situation in which a child is being adopted, they can also include SIJS findings within those court petitions so that the child can file for SIJS, but it's not a pathway to legal adoption. You would still need to work with family attorneys who would assist the minor and the adoptive parents with the legal adoption process.
And I would also flag this webinar definitely doesn't address adoption and immigration. That is a whole other can of worms. I just want to be super clear. There are adoption for immigration purposes is more complex than it seems. It's never enough that it's just a US citizen adopting a child and then automatically that child gets US citizenship. There are a number of rules around that. There are rules about notifying the parents under the Hague Convention. There are age out limitations. So if you are considering adoption as part of an immigration remedy, it's really important to consult with an expert on that. And that's not what's contemplated at all in this webinar. But yes, you can include those findings as part of that adoption.
Next question. Do you guys have any advice on pursuing SIJS for a minor who has a prior removal order? She is 20, so would have to file her I-360 by March at the latest.
Yeah, so you having a prior removal order does not affect. Okay, actually, I'm gonna take that back. I would say prior to the current administration, it was nope, I'm gonna reframe again. So sorry, everyone. So no, so having a prior removal order does not affect the way in which you would approach an SIJS case. We have oftentimes here at NIJC obtained the predicate order and then filed the SIJS petition and gotten it approved, and then you can go about tackling the removal order. That would be a completely separate conversation. So you can definitely apply for SIJS for a minor who has a prior removal order. And then oftentimes an approved SIJS petition could be included in your legal or argument with the court to rescind that prior removal order.
Jordan, do you want to flag the safe address provisions that we use on I-360s?
Yes, so I will flag that under this current administration, we no longer include the client's physical address, because you will note that the I-360 actually never asks in regards to an SIJS applicant their physical address. It only asks for their mailing address, and NIJC has transitioned to only providing the NIJC's mailing address as the client's address with the consent of the client. So filing a I-360 petition, a SIJS petition with USCIS will not alert USCIS, nor will it alert the immigration court of the client's current address. So it will protect them from any sort of like information being revealed to these federal immigration agencies.
And this is not a general practice. There are some forms like the I-360 that allow for a safe address and for that to be the attorney's address. But your client still has the same obligations to update their address and to include an address in any other form. But as a precaution, as Jordan said, we have been doing this on the SIJS form.
And a following question to that one, any concerns with the minor having to go to biometrics for the I-360 with the prior removal order?
I'm gonna let Hillary answer this question, because she has been seeing clients be scheduled for biometrics appointments through their I-360.
Yeah, we don't love that. We are concerned. So far, we have not had a client detained at a biometrics appointment. I feel like maybe I've heard of one on the listserv nationally, but it's so far so good. But yeah, there are definitely more biometrics happening, and that is a concern. We'd want to make a plan with the client and definitely have a signed G28 on file, because it's not out of the realm of possibility.
Okay. And then this question's directly to you, Hillary, about a client being and having deferred action and they were detained. Are you seeing this too?
So I saw Anna's post on the listserv about this. I think, yes, it's not, again, out of the realm of possibility. We have been advocating really hard to try to make sure our clients are not detained, but yeah, deferred action apparently does not prevent detention. And I want to be clear, ICE has the right to detain somebody during their removal proceedings. They previously would have been eligible for a bond hearing at any time, because they have the discretion to allow the person to be out while removal proceedings are pending. But in theory, they could detain someone and try to detain them for the whole time that their removal proceedings are going forward. And we did just recently get a really terrible decision purporting to basically eliminate bond eligibility for anybody who is an iwi. So it is a concern. I think generally we're doing a lot of safety planning, really try to make sure you have those signed G28s and try to make sure your clients are in constant contact with you, because it's getting real.
Thank you. Okay, last question before we move on to the next slide. If a client has an upcoming master hearing, is an SIJS claim enough to have the IJ reschedule their hearing?
Again, the answer to that is going to be, it depends. It's going to very heavily depend on the immigration judge in which year before. It's also going to depend on the trial attorney. But in NIJC's experience, yes, it is a grounds to continue the hearing while you obtain the predicate order, while you file the I-360. We have also seen in the past that a pending I-360 and or an approved I-360 can be grounds to administratively close the proceedings and also terminate the proceedings.
All right, those were all the questions, and I'll pass it to Jordan again.
All right, we have reached the end of our webinar. Thank you so much for attending today, everyone, especially with your very detailed and thoughtful clients regarding the safety, or thoughtful questions regarding the safety of our clients and the immigrant population in general. We are now just going to briefly touch on those who may be interested in taking a pro bono SIJS predicate order case with NIJC. This would only be available to attorneys who are licensed in the state of Illinois, so feel free to stick around if that applies to you. So thank you everyone for attending. As a reminder, the CLE predicate phrase for today is going to be, or code is going to be predicate order, and you will receive an email from Berenice after today's webinar with the slides and then also the survey to complete CLE credit. So real quickly, taking a pro bono case with NIJC will look like this. So we recommend that a predicate order case team be about 1 to 2 attorneys, and 1 attorney on the team must be licensed in Illinois, and the law firm in which these attorneys work also must approve the acceptance of the pro bono predicate order case. And this is because the predicate order case will stay with the law firm even if the pro bono attorney leaves. And then potential associated costs with accepting this type of case is going to be filing fees, interpretation services for client meetings, and then transportation for the client potentially to and from meetings, to and from hearings. And then a time commitment we recommend is about 3 to 6 months if you stay on top of the case. And then a predicate order case, once the predicate order case has been accepted, NIJC expects the pro bono attorneys / law firms to see the case through to its completion. And if accepting a pro bono predicate order case it seems like something you would be interested in taking, please do contact us here on the non-detained kids team. Your first point of contact is going to be Berenice. We've got her phone number and email here. She is our SIJS pro bono project coordinator, and she is excellent at what she does and just a joy to be in contact with. So please reach out to her if you are interested in taking a case. But in the alternative, you can also reach out to myself with my email right there, or our managing attorney, Hillary, as well, because she is the primary point of contact for tech support on these predicate order cases. And that is going to be the conclusion of our presentation for today. And as always, please do contact us with any questions or if you would like to take a case. And we so appreciate you taking time out of your day to learn about SIJS in Illinois.